Hi everyone, welcome back to the channel. Tony here with Italian Dual Citizenship Assistance. And today we're going to talk about eligibility. We're going to talk about who qualifies for Italian citizenship under the new law number 74 of 2025, which officially went into effect on May 24th. This law replaces the earlier emergency decree, Decree 36, and introduces some major changes to how Italian citizenship by descent is handled. This new law is intended to apply to 1948 cases as well, but it has been raised by some attorneys that 1948 cases could technically fall outside of being required to adhere to the new law to some degree. So we'll keep an eye on that and report more about that soon. For now, let's assume that this applies to everyone. Before we get started, a few important notes. First, I'm not an attorney. This is not legal advice. It's an informational summary based on the final published text of law number 74, 2025. Today is Wednesday, May 28th of 2025. So this is the best information we have on the eligibility guidelines for this law as of today. Now, we're still waiting on implementation guidelines from the Ministry of the Interior and local consulates, and some details may be clarified in the coming months. Secondly, the new law is complex, and eligibility now depends not only on your ancestry, but also on the method and timing of your recognition of citizenship. There's already a lot of interpretation and variation in how people are explaining all of this online. I've seen some common points being misinterpreted or overlooked. So this video aims to stick closely to the letter of the law as written and lay things out as clearly as possible. If anything needs adjusting, I'll add a pinned comment, and I will not hesitate to create a new video on eligibility as needed. Now, third, this summary does not cover legal challenges or court-based strategies that could be available to those who are currently blocked under the new law. That's a whole separate topic that I'll be covering in other videos. But it's important to know that this option still exists even under this new framework. Finally, keep in mind that this may not be the end of the story. A more comprehensive reform bill called DDL 1450, which I covered in a separate video dedicated to that bill, is still on the table and could be debated in the coming months. So there's a real possibility that things could change again, either through this law, through political reform, or through legal and constitutional challenges to the law itself. Now, if you find this video helpful, a reminder to please like, subscribe, and share it with anyone who's trying to understand where things stand with Italian citizenship. All right, so let's walk through who qualifies and how the rules have changed. So the law distinguishes between two types of citizen. This is where the new law creates some real contradictions. And on the one hand, it says that if you inherited Italian citizenship at birth, you're a sanguinis, you're a citizen by birth. But on the other hand, if you weren't recognized or didn't apply before March 28th, 2025, then you're treated as a citizen by acquisition for legal purposes. And that's a major shift in the overall view and theory behind Italian citizenship by descent. Italy has essentially created two classes of citizens, those born in Italy and those born abroad. And even among those born abroad, the law now draws a further line between people recognized before the March 28th deadline and everyone else, even if they've been Italian by blood their whole lives. All of this could be a major point of contention with legal challenges moving forward, this division, this inequality in how different groups of people are treated under the new law. So here's information on your screen about citizens by birth versus citizens by acquisition. Under the law, these categories now carry new legal and practical consequences. The law ties many rights and deadlines to whether you are considered a citizen by birth and whether you were recognized or had submitted a qualifying application or court case before the 11:59 p.m. Rome time deadline on March 27, 2025. So anyone who applied before March 28th is going to be viewed under the old rules and has different sets of eligibility and rights under the law. Now, even if you inherited citizenship at birth through your sanguinis, if you didn't meet this March 28th deadline, you are treated as a citizen by acquisition for legal purposes under the new law as written. And we'll see some ways that that impacts you as we move through the different categories in this presentation. All right, we've got 10 different eligibility scenarios we're going to discuss in this video. And we're going to start first with adult applicants. So adult applicants, you qualify if, scenario 1, you were already recognized as an Italian citizen before March 28, 2025. You have full rights, including registration of minor children under the old rules. And as I mentioned, that March 27th at 11:59 p.m. Rome time is the legal cutoff time and date used to determine citizen status for transitional provisions. Scenario number 2, you submitted your citizenship application before the March 28th deadline. This includes consular appointments officially confirmed before March 28th, 2025. So even if your appointment is sometime out in the future, if you got official confirmation of an appointment before the March 28th deadline, you are considered grandfathered under the old rules as it is currently written in this law. Scenario number 3, you filed a court case like a 1948 case before the March 28th deadline. Again, even if your case is out in the future, as long as your case was filed before the March 28th deadline, you are considered under the law as written to be grandfathered in to the pre-decree eligibility rules. Scenario 4, your parent or grandparent holds only Italian citizenship or held only Italian citizenship at the time of their death. This does not apply to great-grandparents, and dual citizenship disqualifies the ancestor. Now, it's important to point out here that this new eligibility criteria of a parent or grandparent holding only Italian citizenship, either now while they're still alive or at the time of death if deceased, does allow for the potential to skip a generation. You could potentially skip a parent if something such as naturalization blocks you from applying through that parent and go back to a grandparent, because as written, it says that you need to have one of these two things, a parent or grandparent that holds the Italian citizenship, exclusive Italian citizenship. So that's a really important note. The idea of being able to skip a generation is not something that has always been able to be done. Scenario 5. With scenario 5, we're getting into minor children at this point, and we'll see some of those differences between the citizens by birth versus citizens by recognition distinction that's being made under the new law with these. Scenario 5, you will qualify if you are the minor child of someone who was recognized as an Italian citizen or submitted an application or court case before the March 28th, 2025 deadline. Now, this applies to people who are currently minors, not looking back to when you or one of your ancestors was a minor. This is people who are currently minors as of right now. This is a limited time scenario. The parent must register you by a deadline of May 31st of 2026, and you must still be under age 18. This option does not apply if your parent was recognized after the March 28, 2025 deadline. This is only for those with parents recognized before the March 28, 2025 deadline. It applies to children born either before or after the parent's recognition, as long as the parent met the deadline and you are still a minor when registered. Make note of that, because not all of these scenarios apply to both before or after the parent's recognition. Now, in scenario number 6, this also applies to minor children who will qualify if you are a minor born or adopted after March 27, 2025, and your Italian citizen parent registers you within 1 year of your birth or adoption. Now, this option is available even if your parent was recognized after the March 27, 2025 deadline, as long as they inherited Italian citizenship at birth through jure sanguinis. This option becomes available only after the parent is officially recognized as an Italian citizen. So this is one of those places where there's a bit of contradiction in the law. So it's saying that as long as they inherited Italian citizenship at birth by jure sanguinis, so this is somebody who was considered eligible to inherit citizenship at birth under jure sanguinis principles, but does not mean that they will be recognized as a citizen by birth for legal purposes because they were recognized after the March 27th deadline. So this is a permanent scenario. May 31st, 2026 deadline does not apply. This is intended for where the parent registers the child within a year of the birth or adoption with no deadlines that need to be met. And this does not apply to parents who acquired citizenship through naturalization, marriage, or reacquisition. Registration must occur within 1 year of the child's birth or adoption. If adopted, the child must still be a minor at the time of the registration. This option only applies if the child is born or adopted after the parent has become an Italian citizen. Scenario number 7 also deals with minor children. Minor children will qualify if you are a minor whose Italian citizen parent missed the 1 year registration deadline we mentioned in a previous scenario, but they legally lived in Italy for 2 continuous years. This can be before or after your birth. This applies only if your parent is a citizen by birth, as distinguished against parents who acquired citizenship through naturalization, marriage, or reacquisition. So this applies only if your parent is a citizen by birth or eligible for being a citizen by birth through jure sanguinis and was either recognized or had submitted a qualifying application or court petition by the March 27th, 2025 deadline. It also applies to minor children covered by the May 31st, 2026 deadline exception in scenario 5. If that deadline was missed, this 2-year residency option can be a backup. It can still be used. The declaration for your citizenship must be made while you are still a minor. The 2 years of legal residence in Italy can occur either before or after your birth. Now, as we saw in those scenarios 5, 6, and 7, as they apply to minor children, there is some distinguishing details between those two types of citizens we discussed: citizens by birth, citizens by acquisition. And so I want to look at that a little bit further here. If you did not apply or become recognized by March 27, 2025, you are treated as a citizen by acquisition under the new law. As a result, you cannot register a child born before your recognition using the May 31st, 2026 exception for minor children. This special deadline is only available for those who meet the March deadline. If you miss the 1 year deadline to register a child born after your registration, your child cannot qualify under the 2-year residency rule. The 2-year residency option is only available if you were recognized before March 28th and are treated as a citizen by birth for legal purposes. Your child born after your recognition will not be treated as having acquired citizenship by birth under the law, meaning they could face limits in passing it on to future generations, especially if born abroad. Now, we have an alternate path also for minor children born before their parents' recognition. If you're not eligible for the automatic registration or special deadlines, there may still be a way to qualify for citizenship by descent, even if the parent applied or was recognized after March 28, 2025, by applying through a standard descent-based claim. So this would be a claim specifically for the child, separate from their parents' claim and not dependent specifically on their parents' recognition. This would apply the same rules as would apply to any applicant, including any adult applicant. So the child would qualify if their parent or grandparent held only Italian citizenship, either at the time of death if they're deceased, or currently holds only Italian citizenship if they're still alive. Now, to use this path, the child must show that their parent or grandparent was not a dual citizen. They apply for recognition based on the parent or grandparent's exclusive Italian citizenships, and they meet the usual documentation and eligibility requirements for descent-based claims. This is not automatic. It doesn't rely on the parent's recognition. It's a separate claim treated as a new application under the law. This route is not available if your parent or grandparent holds another citizenship currently or held another citizenship at the time of death if they're deceased. Great-grandparents are not considered qualifying applicants. So now we've covered minor children. We're going to go back to the remaining 3 options, which could theoretically apply to anyone, including adults. First, we have a residency option. You are the child or grandchild of an Italian citizen, and you live in Italy legally for 2 years. This replaces the old 3-year rule for descendants with a parent or grandparent born in Italy, and the requirement for those for non-EU citizens currently is 10 years of residency in Italy. So this is significantly reduced all the way down now to 2 years. if you have a parent or grandparent who is or was an Italian citizen and you live legally for 2 years in Italy. Now, your ancestor must be a parent or grandparent, or this is an important note here, it could be a great grandparent if your grandparent inherited Italian citizenship at birth through jure sanguinis. In this case, unlike some of the other scenarios, the ancestor may have also held dual citizenship. Now, this interpretation expanding to the third generation is widely accepted, but it is also a point of debate because the law is not explicit on this point. We're following the expert view here, but this is something to keep an eye on whether or not this expansion to the third generation is actually a possibility here under this scenario. We may need to see implementation guidelines from the ministry before we can know for certain. Now, there's no language test required. You may hear some debate that the B1 language requirement from Law 91 of 1992 could stretch to this special descendant route for residency, but in reality, Article 9, Paragraph 1, Letter A, as amended by Law 74 of 2025, only adds a 2-year residency for children and grandchildren of Italian by birth citizens and says nothing about language. The ordinary naturalization paths like the 10-year residency or certain employment-based routes picked up the B1 mandate via ministerial decrees, but since Article 9 makes no mention of it, no one needs to prove Italian proficiency to qualify under this 2-year track, as it seems to be written in the law currently. Now, to qualify, you must have an Italian parent or grandparent who holds Italian citizenship at the time of your application, or if they're deceased, held this Italian citizenship at the time of their death. You need to legally reside in Italy for 2 years, where short absences are okay. Ordinary travel is fine. Stay continuously registered with the local Italian comune. In order to stay for 2 years, you're going to need the ability to stay longer than your typical 90-day tourist visa. So some visas that could support this route include the new quota-free work visa, which we'll look at a little bit in the next section here. The student visa, elective residency visa known as ERV, designed for retirees or those with means. By means, they're referring to the requirement for a minimum amount of passive income. This is for people who don't need to work and don't need to rely on the Italian healthcare system. There's a potential family reunification visa, which would be useful for those who already have family living in Italy to reunify the family. And there's this potential digital nomad visa for remote workers meeting future criteria. Scenario number 9 refers to a new work visa option. And this is if you are a descendant of an Italian citizen and qualify for the new quota-free work visa, you must live in a country with a large history of Italian immigration. That list is coming from the Italian government. You need a job offer from an Italian employer. That's an important point. You must apply from outside of Italy. And final generational rules will be set by ministerial decree. Additional details are subject to future ministerial guidelines. We need more information in the form of implementation guidelines on this one to fully know who all is going to qualify. Once approved, you can move to Italy for work, you can get a residency permit, and you can start the 2-year path to citizenship that we referred to under scenario 8. Now, the 10th and final scenario that we're talking about today is reacquisition of citizenship. If you lost citizenship before 1992, the significance of 1992 is that's the year that the law in Italy allowed for people to hold more than one citizenship. It allowed for dual citizenship. So this is significant for people who lost citizenship before 1992. So if you lost citizenship, you can reacquire it by declaration between July 1st, 2025 and December 31st of 2027. There's no longer a need to move to Italy. The previous reacquisition process did require a period of living in Italy. So no need to move to Italy, but there's a 250 euro consular fee. Some other details here on your screen about this reacquisition program. So as you can see, the new law is quite complex. The bill coming behind it, DDL 1450, is designed to be a longer term plan. That'll be reviewed in the second half of 2025. And it is a lot more thorough and well thought out. The decree was relatively rushed, and it's being converted into law within 60 days, caused it to be further rushed. And you can see that in some of how this law was written and how some of it works with the contradictions. So we're hopeful that DDL 1450 will make things a little clearer and smoother moving forward. So we'll have to see how that all plays out. That bill has been on the table but hasn't really been dealt with yet, as the focus has been on converting the decree law. So that's the overview. Again, this does not cover the legal challenges or court petitions inevitably coming for those who are blocked by all the restrictions in the new law, but those options do exist, and I'll be covering them in future videos. Now, if you need help understanding all of this, there are some ways to move forward and prepare. Have your case reviewed and get clear on eligibility and the best path forward for you. Get expert help gathering your documents quickly. You'll want to avoid paying the $10,000 or more being charged by many of the large agencies. There are a lot of people who are very concerned out there about these large sums that they've paid for these agencies, and they're not receiving responses back and are really concerned about what could happen with their case and their money at this point. So definitely a caveat to avoid spending large sums of money at this point. So if you have questions, you need help, you want to learn more about if you qualify, I invite you to book an affordable 20, 30, or 60-minute consultation with me, which you can do on my website at italiandual.com. We can take a look at your unique case, map out your best path forward, and get you clear on your next steps. So I hope you'll join me for a consultation soon, and I look forward to seeing you in the next video. Thank you.